Ms. Broussard, are you aware that your son in the last 5 years has been arrested for 9 different offenses?
Excuse me?
Are you aware that in the last 5 years your son has been arrested for 9 separate offenses?
9?
Yes, ma'am.
Right away, you can feel the tension in this courtroom. The defendant isn't facing a minor charge here. Aggravated assault with a deadly weapon automatically puts the judge in a no-nonsense mindset. And when a bond is sitting at $300,000, that tells you the court already considers this defendant a serious risk. The big question now: can the defense convince the judge this is a supervision problem or a public safety problem?
Right, Jonah Johnson, 25 DCCR 1775. It's not going to take much for me today to lose mine. I'm right on the verge. I am at my word limit.
Good morning,
Good morning.
I have one witness in this case.
Good morning. Are you Jonah Ray Johnson?
Yes.
And this is 25 DCCR 1775. Mr. Johnson is charged with aggravated assault with a deadly weapon. And Mr. Vasquez has filed a motion asking that I reduce Mr. Johnson's bond, which is currently set at $300,000 in that case. Are you calling your client?
Yes, Your Honor.
Mr. Johnson, best you can, raise your right
Oh,
hand.
no, I'm sorry, Your Honor. I'm not. I'm calling my client's mom, Jacqueline Broussard.
Ms. Broussard? Mr. Johnson, if you'll just come around just to the side, right there on the corner. Ma'am, if you'll come right over here, please. Good morning. And would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You may proceed.
Thank you, Your Honor. Ms. Broussard, state your name for the record, please.
Jacqueline Broussard?
And you've done this before, haven't you?
Yes, ma'am. Oh, sir, I'm sorry.
And you are Jonah's mom, correct?
Yes.
And the original bond back in September was $150,000. Wasn't that correct?
Yes, sir.
And what went wrong? What was the problem there?
The ankle monitor. We thought it was broken, which we was led. That was, we called Johnny, and Johnny told us to come in, which we had been talking with Johnny for 2 weeks. But like I say, Johnny said come in, and something was going on with the monitor. And we also was a payment behind.
Okay.
But we, like, I'm sorry, go ahead.
That's all right. The bondsman said the defendant has failed to pay for the GPS device. It wasn't charged. He will not respond to surety's attempt to reach him. He cannot be located. Surety feels like his bond is at risk. Now, you disagree with that, right?
Yes, sir.
The bond was never at risk.
No, sir.
Jonah lives with you?
Yes, sir.
You live in Beaumont
Yes, sir.
with your husband?
Yes, sir.
And how many people live in that house?
Me, my husband, my oldest son, and Jonah.
And how long have you been in that home?
Over 5 years.
And the 4 of you lived there?
Yes, sir.
Was Jonah working when all this happened?
Yes, sir.
Where was he working?
He was working for Jefferson nursing home.
Say it again?
Jefferson.
What was he doing?
He was working in the kitchen.
And how long did he have that job? You recall?
I think he had just received that one over there, maybe 6 months. I'm not, yeah. Because he just got hired out over there.
And he's 18?
Yes.
He lives with you?
Notice what the defense is doing here. They're painting Jonah as stable, living at home, employed, surrounded by family, not a flight risk. In bond hearings, this is strategic. Judges look at community ties because the stronger your roots, the less likely you are to disappear before trial. But here's the problem. Stability on paper doesn't erase what prosecutors believe happened in that apartment shootout. And trust me, the state is about to hammer that point hard.
Is he a flight risk?
No, sir. He's not.
Are you worried about him taking off or running
No,
off?
sir, I'm not.
And you wouldn't waste your money if you...
No, sir.
What bondsman have you talked to?
I had talked to a professional with Kenya, and I had talked also with Lisa.
Which bondsman was this back in September?
I think that was Ella.
That was Al.
Uh-huh.
Is that who you're talking to now?
Yes, one of them, yes.
And what have your conversations been like with them?
They just ready for me to get in touch with them and see if they're not gonna be reduced. I just had one text me this morning.
Have you talked to them about what amount you would want to, that you're trying to get reduced to? What would be reasonable?
At least 100,000. We had talked on that.
Well, it was 150,000 back then,
Yes, sir.
so it's not really realistic that that the court would drop to 100,000 now.
Mm-hmm.
Are you asking the court to reinstate I don't know if reinstate the correct word, but to go back to the $150,000?
Yes, sir. Yes, sir.
Is that something you think you could work with?
Yes, sir.
They probably want you to sign a contract for $15,000?
Yes, sir.
I think 10% of the door.
Yes, sir.
Would you make sure there was no discrepancies or mistakes or misunderstandings about the GPS monitor system?
Yes, sir.
And what else would you like to tell the judge? About the bond?
We are ready to make fun.
Have you seen the video in this case?
Yes, ma'am.
Okay.
I have talked to my son. Yes, ma'am.
You've actually
And
seen it?
Yes, ma'am.
Okay.
The whole video.
Okay. Anything else?
Nothing else, right?
Questions of this
That was
witness?
actually one of my questions I was going to ask this witness, is whether or not she's seen the video, Judge.
Okay.
In addition to that, Ms. Broussard, are you aware that your son in the last 5 years has been arrested for 9 different offenses?
Excuse me?
Are you aware that in the last 5 years, your son has been arrested for 9 separate offenses?
9?
Yes, ma'am. Evading arrest as a juvenile, UUMV as an adult, possession of a controlled substance, unlawful carry of a firearm.
And there it is. The prosecution just unloaded the defendant's entire arrest history into the room like a stack of bricks. 9 separate offences in 5 years. Weapons charges, drug charges, failure to identify. This is the moment the hearing shifts emotionally, because now the judge isn't just evaluating one incident, she's evaluating a pattern. And in bond hearings, patterns can be devastating.
Firearm, fail to ID, possession of a controlled substance, possession of marijuana, and 2 additional unauthorized carrying of a weapon. Were you aware of those arrests?
Yes.
Okay. Now, the gun that your son allegedly carried back on August the 31st of 2025, during that shootout at the Pine Club Apartments, do you have any idea where you got that gun from?
No, sir.
Are you aware that a bystander was shot during that melee?
Yes, sir.
All right, that's all I have, Judge.
Okay. Any other questions of this witness?
No.
Thank you, ma'am. You can have a seat.
Thank you, ma'am.
Any other witnesses, Mr. Vasquez?
No, Your Honor.
Mr. Pullman?
Judge, one of the items of evidence that I planned on introducing was the video from the shootout. It sounds like the court vividly remembers that. So if the court doesn't wish to see that again, I want to.
Let's just quickly play it. I want to, I'm refreshing my memory by taking, well, first of all, I'm gonna take judicial notice of the court's file. I have reviewed the probable cause affidavit, which is what reminded me of the facts of the case. And I guess it was the other
It was the
case that
co-defendant.
we had a bond hearing on. Is that correct?
Well, no, I take it back. It was this defendant when he was represented by Brittany Holmes, if I'm not mistaken.
So I've had a bond hearing, watched the video on this case.
Yes, Judge, if I'm not mistaken. In fact, when you look at my notes, that would have been January 13th of 2026. My notes include that there was a defense motion to reduce the bond. We argued, you heard evidence and testimony, and that you denied the motion back in January of this year.
So this was after the AFRS, and the bond was at $300,000 on that date for the same bond hearing.
Yes, Judge.
Your motion's denied. I've already heard all the evidence.
If there is something, Judge, I think that it's at least, if you're gonna deny it, I think you may want to consider it as far as whether or not the bond is sufficient. As it states, it's just a 5-minute clip of
Go ahead.
a jail phone call that I've added subtitles to. If I could,
This is a subtle but massive moment legally. The judge basically says, I've already seen this movie. She remembers the video, remembers the previous bond hearing, and reminds everyone she already denied this exact request months earlier. That's brutal for the defense because it means they're not starting fresh. They're trying to reverse a judge who already made up her mind once. And judges rarely like revisiting decisions unless something dramatically changed.
do that. I'm happy to bring my sponsored witness, but if you'll stipulate to it.
No, I'm gonna object to it to relevance.
Bring your witness, please.
State calls Captain Michael Pond.
Good morning, sir.
Morning, Mr.
Thank you for your patience this morning. If you'll please raise your right hand, do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you, sir. Go ahead.
Captain Ponder, would you state your full name for the record, please?
My name is Captain Michael Fonzie.
And Captain Ponder, very briefly, what do you do? What are your duties at the over at the jail? That's your department.
I'm the custodian of records for the Jefferson County Correctional Facility.
And you're familiar as your custodian record with the recording equipment there at the jail, correct?
Yes, sir.
And it's capable of making an accurate recording.
Yes, sir.
Each inmate is issued a unique identifying number, correct?
Yes, sir.
And that's one of the ways to identify who makes certain calls from the jail, correct?
Yes, sir.
Have you had an opportunity to review what I am marking? Judge, do you want me to mark this as states 2 or 3? We entered one in the first hearing back in January. I can do it 1, however you want to do it.
I think, it's technically a new hearing.
Okay, I'll do 1. Okay.
One's fine.
All right, you recognize this USB drive?
Yes, sir.
How do you recognize it?
Because I listened to it this morning.
And are these your initials in today's date that's on the USB drive?
Yes, sir.
I'm marking it as state exhibit number 1. You listened to it. Do you have any doubt that it's a fair and accurate copy of a jail phone call or recording of a telephone call made by an inmate, this inmate, from the Jefferson County Jail?
No, sir. No doubt.
All right, Judge, state officer, state.
Mr. Vasquez?
Good morning. How long is this video?
This is
The
an audio.
recording,
I'm sorry, the audio.
It's about a 5-minute excerpt from a 14-minute and 20-some-odd second phone call.
Well, so it's been altered.
It's been closed, yes.
Object to the alteration now.
Judge, what's on here is the original 14-minute long video as well as the shortened 5-minute video with the subtitles added. So the original's on here.
Okay.
And by the way, I gave it to Mr. Vasquez yesterday, and he's had a chance to preview it.
States 1, with both, will be admitted.
Permission to post, Judge?
Yes.
Judge, can I finish my objection? Judge,
Sure.
object to the alteration, and then there's a transcription. I object to that as hearsay, where you give
The subtitles.
the subtitles of what you think they're saying.
Do you disagree that the subtitles are correct with what you hear?
I don't know, Your Honor. I just object to it being hearsay.
I said hearsay.
Now this is classic courtroom warfare. The defense objects to the subtitles as hearsay, arguing the captions are someone's interpretation of the audio. The prosecutor counters brilliantly. If the defendant's own statements are admissible, then subtitles simply help clarify what's being said. And the judge? She shuts it down immediately. Objection overruled. That's a huge win for the prosecution because now the court gets the emotional impact and easier readability of the jail call.
Subtitles are on it to what it's someone has written in what they've transcribed the conversation to be. I object to that as hearsay.
Mr. Coleman?
Judge, if the audio is not hearsay, which is a statement made by a party opponent, then the subtitles are therefore not hearsay. Judge, it's just,
Obviously, we'll be able to listen myself, and your objection's overruled. It's admitted.
permission to post.
Yes, and that's both the excerpt as well as the entire. And thank you, Captain Ponder.
Yes.
call may be recorded or monitored.
He came back in, he said, but he got still ain't gave probation. The lawyer told they were going to do probation and shit. Well, he was saying, probation and shit. He was like, man, too much shit was going on. Like, wild wheels. He told him, he was like, he got right up and he jumped in and everything. But she locked down and get down. Oh, man. Crazy. People went crazy. Wow. You know, he said people screaming and shit. They say, man, world star type of shit. The burn all over the world. Coming out of that, first it was cool, he was chill. I feel like, bitch, you good, you sure you good, bitch, man, they good, like, I'm good with both. So one day, he just snapped. CO said something to him. They said, what, bitch, I want to play. So I get to it, CO and they want to punch him. They go, come on, you ain't gonna see it. Niggas know he ain't trying to CO and trying to punch, like, boom, he smacked the motherfucking computer, punched that bitch. Straight the motherfucking computer. They come deep in the end though, they said they can't know I'm going in the end though. That bitch put the fire, bitch, I was tricked so good. They ain't this. You gotta do it, you gotta take that. If you go down that trip, you gonna have to go put it up for college for five. Yeah. And they know this is how it points. If my leg so good at first time about you want to leave your citizen to the judge, and I said, yeah, nah, take my shit to trial. I said, they're going out my bus for the discovery, I seen all my evidence and shit. That shit bullshit, bro. I'm gonna take this to trial, bro. They gonna drop the charges. So I told take the charges, boom. My lawyer, he looked at the paperwork and shit, like, oh, you good, you fit, you give him some time. I know it's gonna take time. Because everything that's going on right now, they ain't making it no better. But like I say, they come, even if they come like this, 5-year cap. They gonna say they off probation with a 5-year cap. I take this. I want to be killed. I want it 5 years. But they do 5 for like 2.5 on this bitch. Oh, come on, for the bank. You know, that's the bank time. I'm gonna have some bank time. Sorry, I got 5 months bank time right now. You get 5 months, bitch, man. But it's have 5 months. You know what I'm saying? What I did, boy, that shit look like very good point of the phone, but I think when I really kind of been flying by, it is what you get in this one. You know, but this shit. Very tough position, so I ain't a motherfucker, that shit is very big. So I'm like, man, cause nigga been around young, it's hard to do it like that the way, but you know, push gonna come to shove or some shit gonna happen. Boom, you know, get to the, like, that was my first write-up. Like, bitch, I been chilling, talking, quiet, doing that stuff, like, that there's just write up, got another write up, I got the fighter write up, other fighter write up, man. But at that time, they moved to this door. Shit. They just figure out the time. So they put me on things that you know what's going on, like shit. So plus I just did my first came with it, so I was a KO, boom. I said just come to help leave and go back. Like this, I'm like, hey, I see it back to this, and right, I'm like, there ain't. Oh, hey, they can get out from like, but you see it, you know, I ain't gonna figure the world like this, and I and he, like, yeah, shit, say, give that nigga probation for worse shit, like, this I know. Come out on top of the but you probation when They just gave my other partner, my real partner, nigga had 3 robberies. Hey, gave nigga, I yourself for 3 months, 10 year probation. That's what I'm talking about. They gave I yourself 3 months, 3 months I yourself. He got 10 years probation. After he was already on probation, 10 years. But crazy, even the dude that got in the fight with the court, the same thing.
That's all I have on that, Judge. State has no further witnesses.
All right, anything else?
No, Your Honor.
Okay. So at this time, I am going to deny.
And just like that, motion denied. But listen carefully to the judge's reasoning here. She's not only focused on the alleged violence, she's focused on compliance. Missed GPS payments, trouble contacting the defendant, concerns about supervision. In the court's eyes, bond isn't just about money, it's about trust. And right now, the judge is basically saying she doesn't trust this defendant outside jail walls.
The motion for a bond reduction. And I guess, Mr. Coleman, depending on any future incidents, if the state wishes to file a motion to increase, I would look at that at the appropriate time.
We have contemplated that, Judge.
But, Mr. Johnson, a condition still, if you make that $300,000 bond, is that you would be on house arrest. You would be required to wear a GPS monitoring device at all times. Part of the reason that I'm doing this is because it sounds like you were working, your parents have the issues. I've looked at the bond, the affidavit for them to release surety. It's not just the GPS monitoring device. They obviously were having a hard time getting in touch with you for whatever reason. So I think that makes obviously one of the criteria under 17.15 for bail is that obviously you have to follow all of the rules and conditions of bond, which is with your bondsman as well. And so we will reset your case for an announcement, and Mr. Vasquez will visit with Mr. Coleman, get any offers in your case, and we'll either take a plea if you wish to take a plea at the next court date, or if you don't, we'll do a rejection and get your case set for trial. All right, you can go back with the bailiff.